today say, we have not done anything and we are not supposed to do anything. If this is the state of affairs of legislative interference or legislative response to judgments of this court, I have no choice but to knock at the doors of this court and say, Lord, I have a sense of deja vu. I was here. I opened the case on 377 years ago, before 5 judges, 5 years ago, in this court. This is how, my Lord, we reach step 1. And there is a passage in Justice Chandrachud's verdict, which I will show, my Lord, that this was the first step. That is that sense. This was the first step. Remove that obstacle. Bring them up to the mark with the others. They will walk, my Lord, shoulder to shoulder. The Constitution said secular. What is secular? Regardless of caste, creed, color, sexual orientation, full expression. So we are a part of one homogeneous whole, but with dissimilarities of caste, creed, color, religion. But everybody is entitled in our secular polity, a pluralistic society. Justice Abarwal, Lord, in Coelho, secularism is a part of basic structure. Equality is a part of basic structure. If they are a part of basic structure and a part of the triangle, Lord, I would say quadrangle, not triangle, 14, 15, 19 and 21. If they are a part of that which are inalienable, part of the basic structure, cannot be removed by anybody, cannot be tinkered by anybody, as understood by your lordships. I am not reinventing the wheel. Whatever I am saying, Lord, is actually a paraphrase of what I have read in the last couple of days from those judgments. And I will show you some passages. I am only going to put the pieces together, Lord. And I have, my Lord, for your lordship's, my Lord, convenience, Justice Bhatt might recall, my Lord, in that reservation case, I had made a big chart to show you how the judgments went, my Lord, in reservation. B3. Here I have made, my Lord, your lordships found it, my Lord, useful. Here I have, just hold on, Lord. I have made, my Lord, a one-page chart. Starts, my Lord, with, my Lord, 1860, the penal code. Your lordship, just have a quick glance. It will be easy. This will give your lordship, my Lord, a very quick glance. Because I think only Justice Bhatt was there, my Lord, in that case of the 5 judges here. Yeah. Kindly, my Lord, just see. Input by juniors, not by me. I only dictated, my Lord, the flow. So, yes, so today is the rainbow, my Lord. This is the rainbow. Kindly see, my Lord, Penal Code by Macaulay. In fact, Justice Chandrachud has used, my Lord, the full name of Macaulay, which I didn't, which said Babington. Yes. Then, my Lord, these were laws introduced in different colonies under the British Empire. 47 is our constitution. 67, my Lord, was the Sexual Offences Act enacted by Parliament, which legalized homosexuality in 67. Now, see, my Lord, September 96, US is very, very, my Lord, interesting. US federal government enacted DOMA, which stated that federal law shall not recognize the same-sex marriage. Because, my Lord, pausing here for a minute, some states had started recognizing. So center came and said, we will not recognize, because they have state and central lordship. So they found, my Lord, this DOMA that we want to keep away. Then, my Lord, came Lawrence versus Texas. This was a case where there was a raid, my Lord, in the house of Mr. Lawrence. And during the raid, he was found to be, my Lord, committing an act which was held to be this unnatural act. And he was then charged. Object was raid, but they found him, my Lord, in the bedroom, etc. So, in Lawrence, my Lord, the Supreme Court upheld the right of Lawrence. It struck down, my Lord, that Texas law, which was, my Lord, akin to our 377. Then came Nas. Now see 2013. In Windsor, my Lord, the Supreme Court struck down DOMA. That is, the federal law was struck down by the Supreme Court, my Lord, by the US Supreme Court. Then came, my Lord, Kaushal, which reversed, my Lord, the Delhi High Court. Then 2013, the UK Parliament enacted another act to confer equal rights and protect dignity of same sex. 2014 is our NALSA. Now mark 15. In 15, my Lord, in Obergefell, it recognized the rights of same sex, legalized the same in the country. My Lord, your lordship may mark, and I will show the definition of marriage in this judgment is classic. What is marriage? How, my lord, important it is. I'm going to show that. How important it is. And this happened, my lord, in 2015. And this is referred to, my lord, in Navtej and Shaira Banu both. Then, my lord, came Puttu Swami. I am not reading, my lord. But there are some passages, my lord, of His Lordship Justice Chandrachud, as His Lordship then was. And I have given those passages which I am going to read. And some passages of Justice Sanjay Kaul. Then, my lord, Shafin Jahan and Shakti Vahini. Here also, my lord, if I may say so, the common thread is the Chief Justice. In regard to, my lord, the right to marry a person of your own choice. If you have a right to marry, my lord, a person of your own choice in the heterosexual group, and we are identical to them in terms of our right, it follows, it's QED, it follows that we should also get it. And therefore, you will have to, my lord, qualitatively interpret the laws which were framed in 54 to now fall in sync with what your lordships have said in the last 5 years. That is, my lord, Shafin Jahan. Then came, my lord, Article Section 373 of Johar. Then in 2022, US enacted Respect of Marriage Act for protecting validity of same-sex marriages. Currently, 31 countries recognize the same-sex. I've given the names. Then came Deepika Singh, Lordship, Lord the Chief Justice. Again, right to marry, familial relationships, or even queer relationships, as they are called, is specifically, my lord, dealt with, and that it should be, my lord, can be a family unit, etc. Now, see, my lord, the last definition of marriage in 1968 in blacks. Marriage is distinguished from agreement to marry and from the acts of becoming married is a civil status condition relation of one man and woman united in life, in law for life for the discharge the other and communities of duty legally incumbent or those whose association is founded definition of sex. Union relies on. Now it's changed. Now, my lord, your lordship may mark here, the union relies on the 1968 definition in the counter affidavit. A detailed counter has been filed by the union of 40 pages. So it's not correct to say that I have to now again look at, my lord, what the government will say. They filed a big affidavit, very big affidavit. And they rely, my lord, on the 68 definition. But see, my lord, the definition of 2019, after, my lord, society has evolved. The legal union of a couple. The essentials of valid marriage are parties legally capable of marriage, mutual consent, any actual contract in the form of law. Definition, Lord, of same-sex 2019, ceremonial unit of two people of the same sex, whether man or woman. This is the evolution. So, my lord, union, government of India is following blacks, but it is following an antiquated edition. If you are following the same, my lord, definition or the same dictionary, I say follow the latest version. You can't follow a version, my lord, which is 50 years old. So, ultimately, my lord, it is this. The Chief Justice has put it. I want, my lord, I request, not want, I request. For example, my lord, the two petitioners in the first case, who are they? Two individuals who met, who had a bond of faith, love, partnership. They want to, my lord, reach the status of a married couple, like the other persons, and have a family. They cherish the same, my lord, what is cherished by the others. They want to lead a dignified life, what the others also lead, and not always to be looked upon. Look at them, look at them. For that, your lordships have removed the one block, that they can't go to jail. The second step has to be affirmative, which is a recognition of the right to marriage so that we are equal, recognized by the state, so that, my lord, society then follows the state. Because society, my lord, is resistant to change. Human beings are resistant to change. So society follows what the law is, and the law is what is, my lord, said in parliament or what is declared by this court. That is the law.
The only thing which we'll also need to apply mind to, if you look at your chart,
my lord,
if you see the US, September 96, the federal government enacts the Defense of Marriage Act.
Yes.
Which says that the federal law shall not recognize same-sex marriage. Then comes 2013, of course, the UK,
Or UK.
Windsor. That's right.
Yes.
And then 2013 comes the act in the UK, conferring upon all same.
Lord, Windsor is also there.
Yes.
Windsor, Lord, 2013.
Yes, that's right. Windsor.
When Doma was struck down, the federal law was struck down.
And struck down Doma.
My Lord.
Right. Then comes in the UK, you have a legislation which recognizes same-sex relationship.
My Lord.
And then finally in 2022, you have the US Respect for Marriage Act.
Yes.
2022.
Yes.
So you had in the US something which was debilitating, which was removed from the statute book. Then you have something positive which is enacted in the UK, and then which is enacted in the US as well, the 2022 legislation. Now, what we therefore have to really consider is exactly what the other side is urging.
Yes, I understand
that
the drift of the question anyway.
These essentially matters where even in the US and the UK, legislature has intervened earlier by outlawing and later on by recognizing. In the absence of legislation, how does the court go about it?
Yes, I understand the question.
Is there a contra? I mean, is there any indication in our legislation precluding the court?
Yes.
Or is there a legislative space within which the court can then
I understood the question. My respectful submission, Lord. One, Milord, your Lordship may see the judgment is over Jeffel in 2015.
What is the right of marriage and what is the constitutionality of an enforcement of right of marriage? Because what they are saying is you live together, you want to do whatever you want, but you can't tell that you want to perform whatever ceremony you want to do or whatever you call it as a marriage, but you can't give an imprimatur and say that that will be registered or recognized. Therefore, we'll have to go back to what is the enforceability of a right of marriage.
So, Milord, if I may answer first the Chief Justice. Milord, if your Lordship says 2015, I have understood the drift, Milord, there the legislatures acted. They acted. Pursuant to the judgments or feelings of people, they acted. Here, but in 2015, Milord, as far as Ober Jeffel is concerned, it recognized the right of the same-sex marriage and legalized the same. That was a judicial imprimatur. It legalized.
Correct me if I'm wrong.
Sorry.
There were constitutions and there were laws which were amended or enacted which prohibited gay or same-sex marriages. Same-sex marriages. Obergefell actually struck down that and said,
Right.
you have a right to marry. Now, the wheel has turned a full circle where you have a complete federal cover in the sense that you have a
Yes, your Lordship is right.
right? So we are at that stage.
Yes.
So
Yes, your Lordship is right.
input is we are at that stage. So how do we go about this?
So, my Lord,
One is the declaration part
which I am seeking. My Lord, what I am respectfully submitting, answer to both of your Lords, three of your Lords. My Lord, if, as distinct from UK and other places, if we have a fundamental right under 14, 19, 21, whatever, to be treated as identical and equal to our other brethren, then the full enjoyment of our rights to be equal to them includes the right of dignified life. If it includes the right of dignified life, which includes the right to choose a partner for marriage or choose a friend or a freedom of expression, whatever we want to express, need not only be in writing, expression can be, my Lord, in love or other forms. And that it is now settled that it is innate, it is not an acquired, my Lord, thing, call it queer, call it what you like. If the rights have to be identical, then I must get the recognition of my union the same way as the recognition of the union of two others. And since it is based on an infraction or an implementation of my fundamental right, I can come to the court and the court need not wait for the legislature. And there is a direct passage, my Lord, in one of these judgments in Shahraban. So, my Lord, I can't keep waiting. There can't be a mandamus to the legislature. Legislature may or may not do. I cannot force the legislature, neither can the court. By that time, our lives will have gone. And our fundamental rights will be in name. That there is 5 judgments of the Supreme Court saying that you have the same rights, same panoply of rights, passage after passage. If it is the same panoply of rights, there must be a remedy. And the remedy can only be a declaration to that effect by the highest court of the land. saying that this is a fundamental right. And once it is the imprimatur of this court, then, my lord, it must follow that the state is bound to respect it. Then the society will respect it, and the stigma in the workplace or the public place will then go away, and I'll be able to enjoy, my lord, a unit of marriage, a unit of family. Because that is what is accepted in our society. So in short, I need not wait for Parliament to do what it wants to do, because there can be no mandamus. And then the lordships have said repeatedly, if fundamental right is involved, the doors of this court are open to an individual. I have a right to come here. I have a right to complain that this is what is happening to me in real life. You know, it is happening to us in real life. When we go out, when we talk, when we meet people. Slowly, my lord, it is being accepted because the criminality is gone, but not to its full panoply. Because people say, what right have you to get married? Which law? Which court? You got a judgment from the Supreme Court in the first one. Where is the second one? So unless and until, my lord, I get a recognition of law under Article 141, because that the other legislative thing is not available to me. Vishakha, whatever. If I have, my lord, a right, that right must be examined by the court, and if found, it must be guaranteed. 32 itself is a part of fundamental rights. It must be guaranteed by the court. How will the court guarantee it? My lord, it's not a case of property that your lordship will take it from him and give it to me. Or some money, my lord, taken from me and give it to him. Your lordships will, my lord, give it by a process which is known to law, which is, my lord, interpretation of my fundamental rights, and thereafter interpretation of the law concerned. And then leave it to Parliament that this the court has done. If you want to formalize it in law, as Justice Bhatt put it, if you want to formalize it in law, you jolly well amend the act or do bring a new act, as these countries have done. But if you don't, my lord, the law can't remain static. Law moves, society moves, there's evolution. Rights are different, things are different, thoughts are different. Therefore, the court will act when it is called upon to act. It will do whatever it can within, my lord, its judicial parameters.